Thanks very much. Good morning. My talk is going to be a bit different to what we have heard so far because we've been hearing about the background of Insurtech, how the Insurtech facilities are developed and then they are built into insurance companies, or they are bought by them. Mine is looking at actually a little bit in terms of the chronology. If you look at how insurance contracts operate, then first you prepare the product, and then you sell the product, then the assured purchases it, and then if there is a loss, then the assured makes a claim, and then how that claim is assessed by the insurers. So where actually then the insurance contract law principles play an important role. So my talk is looking into that stage a bit later, a lot later than what the stage that we have been hearing about so far. So when we talk about insurance law, we can talk about two different aspects of insurance law. One, we should separate these two from each other. One of them is insurance regulations. For instance, yesterday we heard about good driver scheme that is about to be launched. Then if it is going to be launched, then obviously that has to be first approved by the regulators. That's the insurance regulation of insurance. And that's not what I am going to talk about, although I am going to touch a little bit about the Financial Conduct Authority because that has something to do with the regulation, of course. But insurance contract law, however, deals with the contractual relationship between the assured and the insurer. Whether we realize it or not, every day we enter into so many contractual relationships. And insurance is also a contractual relationship. When I take out an insurance cover, I am making a contract with an insurer. And that relationship is going to be governed by the terms of the contract. The terms are there. So if you remember yesterday's presentation made by the gentleman from Hiscox, he showed a picture where there was a devastated driver after a car accident. And after that car accident, then you can tell him actually that why are you feeling devastated? If you have an insurance, you can make an insurance claim, unless there is obviously serious bodily injury or loss of life. Then he makes a claim. If the insurer pays, then everybody is happy. Then if the insurer rejects the claim, whether that person should challenge the insurer or not, that's where insurance contract law principles come into place. That's where lawyers also come into place because they advise the insurer whether the insurer should pay or not. They advise the assured whether the assured should challenge that rejection in case the insurer rejects it or not. And whether or not the insurer pays, or whether the assured should challenge the insurer's rejection of the claim, that's subject to so many different principles, and they are contractual principles. These contractual principles, they have been developed over centuries. They are established principles, but actually they also change from time to time. They develop as well. So the way that the industry develops and then needs appear in terms of the legal principles governing the insurance contractual relationships, the courts also develop those principles. I say courts because I'm talking about English law, I'm talking about the common law systems. So in a common law system, mostly the legal principles are to be found in the cases, court cases, whereas in a court-based system, for instance, Germany, mostly you see the legal principles in the codes, relevant codes, but in a common law system, you see in the court decisions the issues. Of course, there are some legislation, pieces of legislation, but not so much. In one country, you can see, you open a code and then you see 1,000 sections there. But in England, you may open an act which has only 3 sections. So this is how actually the cases are effective in the common law system. And then there's a new dispute, new case, new decision the law develops. A recent example is the COVID-19 cases. After the COVID-19 outbreak, obviously, the small business and enterprise, they made business interruption claims and most of them were rejected. The FCA intervened and then brought a test case. And now we have a lot more clarity in terms of the business interruption losses. And the legal principles governing the policies, they insured business interruption insurance. So my question therefore was, when I first heard about Insurtech, and is this now a disruption? Hence then, is this making dramatic changes which also the legal developments should follow? Or is it kind of, as yesterday, for instance, we heard about this maybe disruption, the word disruption may be a misplaced word here. It could be actually strategic augmentation. So that's what I am going to question by introducing the legal principles a little bit to you. I'm aware that you are not lawyers, so I'm not going to go into the detailed legal explanations, but I will try to simplify them and then explain the main principles governing insurance contractual relationships. Formation of insurance contracts, it all starts from there. Because in order to be able to say you have a contract, you must have a contract which is legally recognized. Don't assume that because you have a piece of paper or you have a piece of promise from someone, you have a binding contract. A binding contract is subject to the requirements of a binding contract. And in the insurance context, you also analyze that. Is there a binding agreement? And if it is actually at Lloyd's, then there's this special procedure followed at Lloyd's. Yesterday, with regards to Key, we heard a little bit about that. Mel, for instance, mentioned about words, syndicate, brokers, managing agents, lines, for instance. Have they changed? No, we heard that actually this algorithm is used for the quotations, and that actually now enables quotations to be obtained in 10 seconds rather than 2 weeks. So you can see that it's a faster solution now to make a quotation. In other words, to make an offer to the assured. And if the assured is happy with that, the assured accepts that. So in this respect, I can't really see that dramatic changes, which should also require the legal changes there too. And then actually, this has been the procedure followed in the Lloyd's market since the very early days of Lloyd's, when Lloyd's was a coffee house where the traders, they used to meet, and they used to share the risks there, discussing the risk in the coffee house and then insuring 10% of it, 20% of it, 30% of it. And it's still the same followed today, centuries later. Here is maybe where it becomes a little bit more controversial, the duty of fair presentation of the risk, because we heard again lots of relevant matters yesterday about that, especially if you were here during the panel. Then we discussed, for instance, whether some drivers became uninsurable. Is this an ethical matter? Is it okay for the insurers ask drivers to use telematics? What about the ones who don't use telematics? Is this really a problem? So I can't see it that much of a problem, to be honest. That's obviously my view. But first of all, again, I'm going to refer to Chris's talk yesterday. Then he said that insurers have always collected data, and still they collect data. Indeed. It's just the way of collecting data has changed. But the data, they always needed that. There is a court case decided in late 17th century in which the judge said, insurance contracts are contracts upon utmost good faith. So what does that mean? The insurers rely on the information provided by the assured because the insurers don't know anything about the assured. The assured provides the information. The insured decides to insure or not. The insurer decides to exclude one risk or not. The insurer decides how much premium to be paid, how much deductible, what is the maximum limit here, on the basis of the information provided by the assured. The insurers have always been allowed to have that, and they are still allowed to have that. The thing here is this, however, what is changing is that the duty is on the assured. It's a heavy duty if you consider that, especially if it is a consumer assured, because the assured is required to guess what sort of information the insurer would want to know. Can you guess that always? Sometimes yes, sometimes no. It doesn't really matter whether you guessed it accurately or not. If you fail to disclose it, then the law says you failed to disclose it, and that there has to be some consequences out of that. Now, because the insurers have all these data, maybe it is becoming more difficult for the insurer to argue that, look, you failed to disclose that you had a criminal conviction. You failed to disclose that your business partner argued that you had some court cases between you that you allegedly defrauded them. You failed to disclose that you have some issues with the tax authorities, because all of these things are material facts. The insurers are allowed to know. The insurers are also allowed to know the driver's behavioral characteristics and habits. So telematics, for instance, if the driver is happy to have that, that will obviously build up a profile. And when the contract is renewed, the insurer takes that into account and allowed to do that. In the previous year, this driver has been very careful, no speeding conviction, nothing, then assesses the risk accordingly. So in consumer insurance, the duty is not to misrepresent material facts. In business insurance, the duty is to disclose, in other words, volunteer the information, and also not to disclose, not to misrepresent material facts. In this respect, proposal forms are very important in both consumer insurance and business insurance. And I'm going to refer to, for instance, the selfie example that we heard yesterday. So you are taking out an insurance contract by uploading your selfie. Then is the insurer not asking any questions? If the insurer is not asking any questions, don't worry about it. There is no way that you will be in breach of duty of fair presentation of the risk, because the duty in consumer insurance to answer the questions truthfully. There is no duty to volunteer the information. But things change if the insurer adds one statement there, or maybe 2 paragraphs. I declare that I have no chronic illnesses. I declare that I have never made a fraudulent claim. This is another way of saying, have you ever made a fraudulent claim? Have you ever smoked? Do you have any chronic illnesses? Whether you answer that or whether you declare that, it goes to the same direction, because you're making a statement. And if that statement is false, there have to be consequences, because that will be breach of duty of fair presentation of the risk. For businesses, it is different. Because for businesses are under the duty to disclose material facts, although there are no questions. So therefore, if I am a business and taking out an insurance contract, I have to declare the material facts to the insurer. If I don't, if I fail to do that, then there will be consequences. But if the insurer has all the data available, material facts there, in other words, what I know is also known by the insurer, I am not under the duty to disclose that. If the insurer argues that I breached it, then I can argue that instead of simply accepting that and then, oh, well, tough luck, I lost the insurance claim, I can challenge it and then say, look, you have all the information in your data. If you have it, you can't argue that I failed to disclose something that you already know. So the principles, therefore, are there, and they are not changing, but it's just that the way that who argues what and what is proved in what way is changing. The other matter is understanding the insurance contract. This is where most of the insurance disputes arise, because insurance contracts are generally technical and they include technical terms. Of course, we can read and understand an insurance contract, but reading and understanding it from sort of a person who can read and understand, but from a lawyer's point of view, are 2 different things. Insurance contract may use the term warranty, condition precedent. How do you know what they mean unless you read all the cases about conditions and warranties? You can't. But it doesn't matter whether you know, you understand or not. You are bound by this. If you actually took out your insurance contract through a broker, and if the broker didn't explain you the meaning of the contract, you could later claim against the broker. But how many people would know that there is an actually right of action against brokers in case brokers are negligent? So understanding the insurance contracts and understanding the obligations imposed on the assured is so crucial to make a claim, because there is a breach of contract, there is no claim. If, for instance, the insurance contract said there is some war somewhere, some part of the world, the insurance contract says warranty, do not go to any war zones. You go to the war zone. That is a breach of contract. So or the insurance contract says, notify the claim within 3 days. This is a condition precedent. You notified it on the 5th day. There's a breach of contract. And it results in losing the claim if it is a condition precedent. How can you expect that a consumer would know that, or even a business would know that? So in this respect, I think, again, telematics and this close maybe interaction between the insurers and the assured would make actually insurance contracts maybe more workable for both parties, if I use the word workable there. Or maybe yesterday, again, we talked about sort of building trust sort of between the insurer and the assured. Maybe this will help building that trust a bit more, because you would be more aware of the continuing obligations. And so then you comply with these continuing obligations. Otherwise, you know that there will be some consequences. You may not necessarily know the details of those consequences, but you will be more precautious in terms of, for instance, closing the windows or maybe leaving them open, or not leaving the house unoccupied for more than 30 days. The contract may say, don't leave the house unoccupied for more than 30 days, otherwise we will not pay you claim. You left the house unoccupied for 32 days, you're in breach of contract. You didn't know that, it doesn't really matter, you're in breach. But if you actually are interacting with the insurer, then you would be more aware of that. That means there will be perhaps less breaches of contract, maybe more coverages there available for the assured, because these obligations are really, really at the heart of insurance claims, and where the claims are rejected for those reasons, and insurers are sometimes right, sometimes not. Understanding of deductibles or maximum liability, now with the simplified ways of taking out insurance contract, again, they may be more clear to the assured, because there are lots of cases in which the assured suffered loss, but the deductible wording was so complicated or technical that the insurance contract actually was not suitable for the assured at all, and then couldn't make a claim. These things happen. In terms of the broker's roles and payment of premium, I couldn't really see, again, whether there are any big disruptions, because, for instance, with regards to business risks and Lloyd's, we heard yesterday from, in terms of Key from Mel, that they actually worked closely with brokers to develop that platform, and brokers still are contacting the managing agents face to face. And again, it's on that respect, things seem to be as they have been. Causation actually is an interesting matter, because we heard lots about fraud detection this morning, and I was thinking that, for instance, the example that the roof leakage, and I was assuming that the insurer is working, I mean, not deciding only on the basis of a phone call, but probably looking for pictures and analyzing them as well, because what caused the loss is proven as a matter of fact and as a matter of law. As a matter of law, there's this principle, you don't need to know the details about it, but causation is proven as a matter of fact. So, yes, witness statements or pictures, they prove what happened, and whether, for instance, the loss was caused by flood, the flood caused by natural resources, or maybe a pipe leakage, because the insurance contract maybe excluded the pipe leakage. Yes, there is a flood by pipe leakage, and then there is no coverage, although the assured thought that, well, I have insurance against flood, so I have coverage, but there is none there. So, so causation is obviously that what caused the loss has to be proved by the assured. The assured has to bear this burden of proof. And now the new technologies seem to be enabling, maybe more quickly and clearly proving what caused the loss. The word indemnity yesterday was used, so it was. It's a technical term, obviously, and the assured, in other words, it means that the assured cannot claim any more than what the assured lost. So if the assured, for instance, lost only £10,000 worth of claim, the assured can only claim £10,000 of, but no more than that. So, and again, the new technologies, if they are communicating it well with the insurers then can understand the conditions of those indemnities, at least monetary limits, more clearly. Subrogation is, again, it may be actually working now better for the insurers with the data available for them after for instance, the loss occurred or during the time that the loss is occurring. Because subrogation is that when the insurer pays the claim to the assured, the insurer looks for a third party who is liable for the loss. Because if there's a third party who is liable for the loss, the insurer, after paying out the claim, can step into the shoes of the assured and ask the third party to pay it back to the insurer. That's subrogation. And if detecting a third party, who is the third party who caused the loss, may be easier, and in which case it actually works better for the insurer. With regards to claims, obviously, we heard a lot about the claims process, and some insurers, obviously, they say, oh, we actually decide to pay or not to pay within seconds rather than days and hours. That's obviously improved customer protection. And fraud detection, obviously, again, we heard a lot about this, and it seems to be the most important aspect, maybe, or the concern for the insurer. But this fraud detection seems to be, hopefully, not be confused with the causation and proving what caused the loss, because the assured has to prove what caused the loss. And the assured has to prove it on the balance of probabilities. That means if there is sufficient evidence there proving there is more than 50% chance that that caused the loss, what the assured argues, then that actually burden of proof is satisfied. If the assured cannot prove that, it doesn't mean necessarily that the claim is fraudulent. It means that the assured did not satisfy the burden of proof. And if that is not satisfied, the claim can be rejected by the insurers. So, hence, the insurers should be careful, in my view, in their assessment and classification of the claim as a fraudulent or not fraudulent, because not every single unproven claim is fraudulent, and the insurers have to prove fraud. Because if you argue someone is fraudulent, you have to prove it. And if you're arguing the proving fraud, the burden of proof is rather high. Simply arguing, oh, that's fraudulent because they're suspicious, that's not enough. And when you are rejecting the claim, how you draft it is important. Because if you say that you made a fraudulent claim, that's why we are rejecting it, then the assured will say, well, then prove my fraud. So that has to be proven with higher standards than simply on the balance of probabilities. What goes to that? What sort of implications may arise as a result of this? So insurers, first of all, if they delay unreasonably, because let's say that the assured is not someone that, oh, my claim is rejected, or this is one of those things, I forget about it. It may say that. There are people like that. Or there are people who say that, no, actually, I am going to challenge this because I am entitled, I have no fraud here, and I want my claim. If they challenge it, and then if the payment delays, the insurer may end up paying the compensation plus damages for late payment, because now under English law, damages for late payment is allowed. It didn't used to be. Another thing is, if this happens only not in one occasion, but in hundreds or thousands of occasions, that may go to the Financial Conduct Authority for untreatment of customers. And the Financial Conduct Authority may then fine the insurance company, and then they may lose millions out of that. I read, actually, it was a few years ago, I read that 2 companies were fined because of misjudgment of the claims and wrongly denial of the claims. They had to assess all of those claims again and then pay to the assured, as well as paying millions of pounds of fines to the FCA. So these things are therefore, they may be costly for the insurers. It's very important, hence, to be exact in terms of the terminology when we define things either negligent or fraudulent, or whether you couldn't prove the loss or whether, no, actually you made a fraudulent claim. So is this a disruption or is this not? I am rather inclined to say that no, not the insurance industry or general principles of insurance, of they being disrupted to a great extent. The changes are there, that's for sure. But they seem to be more like in the mode of collecting data, in the mode of proving that the duty of fair representation of the risk is satisfied. Perhaps the insurance contracts are more understandable for assureds now, as well as hopefully insurers, because insurers may not always understand the insurance contractual terms either. We have court cases explaining that. So there seems to be obviously simplifications, and automation is certainly faster and cheaper for the insurers. But is this better? I think if there were time, we could discuss it more, because better, for whom it is better, what does better mean, or it refers to. And compensation or risk prevention obviously is a very good point, because especially using telematics and then preventing risks, sort of making the assured more aware of importance of prevention risk, I think it works really well there, at least from where I stand. And fair pricing, again, is important, because consumers, they have to be treated fairly, because the FCA, Financial Conduct Authority, and the relevant insurance regulations say that. And if there is a problem there with regard to fair treatment, obviously the assured can complain to the insurance company. The insurance company has to have this internal system to answer these complaints. And if that complaint is not resolved satisfactorily for the consumer, they can go to the Financial Ombudsman Service. It can go on and on. So it is therefore important to assess what is fair, obviously, for insurers and assured, and hopefully this will be a smooth process as the parties desire. Thanks very much, and if you have any questions, I'm happy to take them. Thank you.